Hey there, it's Shadi Schaefer again from the Asset Protection and Elder Law Center. Today I wanted to talk about a really important question that I get oftentimes when I'm preparing a living trust or revocable trust plan or an estate plan for families. A lot of questions I often get are, hey Shadi, is this a private document? Or is this information going to be somewhere and be public? Does the court get these documents that you're preparing for me? So the first thing you need to know is that estate planning is a private affair, okay? So the documents that you create, like a revocable living trust, a will, advanced healthcare directives, or durable financial power of attorney documents. All these documents are private. They're there for you to use when life happens, when a loved one becomes ill or they die. It's not something that is public information or public record. So believe it or not, when I create a trust and I transfer a home into the trust, that document is not filed anywhere. It's not like the trust becomes public record and people know who your beneficiaries are and what you're doing in that trust, okay? So all of this is private. Another really important question I get, and it's a really good one, is do I lose any control? This is an extremely important question, and the answer is no, you do not. Okay, so now of course it depends on how you draft your trust and how you design the trust, but generally speaking, a revocable trust is a document that's created, and the only time you're giving your successor trustee or your agent control is only if you become ill, incapacitated, or you've passed away. Now, of course, like I said earlier, you could design your trust and you could put someone in control at a different time. But generally speaking, when attorneys draft these documents, when trust attorneys and estate attorneys draft these documents, we're drafting them with the understanding that, hey, my client wants control. Of course, we all want control of our lives. No one wants to give up control. And so 95% of the time, we're drafting these documents where you have control, and the only time that the person you've appointed to make decisions for you and follow your instructions. Now remember, this is like a love letter of instructions. You are giving the instructions. Your agent or your trustee has to follow your instructions. And so the only time that they step in is when something's happened to you. And this is important because if you don't have these documents in place, what happens? You have to go through the conservatorship court, you have to go through probate court. And you know me, no one wants to go through that. It is extremely important that you have these plans in place so that your family or the people that you trust, your circle of people, can manage your affairs without the court's involvement and supervision, okay? So remember, when you go into court, public. When you stay out of court with the proper estate planning documents, everything is private, and ultimately you are in control 100%. Thanks for listening. Shadi Schaefer, Asset Protection, Elder Law Center.